Howie here.
Hello.
With one of our updates. So we wanted to first talk about Mother's Day. Wish all the mothers out there, especially my mom Eileen, my mother-in-law Rhoda.
And my mom Gladys, and my mother-in-law Debbie, and my other mother-in-law Mickey.
A very, very happy Mother's Day to all.
Yes.
Florida's legislative session just ended on Friday, right before we're taping this, of last week. And there are some updates for you, so I'm going to give that to you first. And then Florida's also been unfortunately busy in the administrative law arena, and Howie will talk about that. So first, a legislative update. We were pretty busy this legislative session, but the laws that we're most proud of and that we want you all to be aware of is that we've strengthened the exploitation laws against the vulnerable adults here in Florida. So if an exploiter, children, or a friend, takes exploitation action against their parent or a loved one or a friend, they will no longer be able to inherit from that person. It's similar to the Slayer statute, which said that if you kill someone, you don't get to inherit from them, obviously, because you killed them maybe to inherit, and so you can't do that. And it'll be the same thing for the exploiter. It has some nuances with burdens of proof and civil or criminal exploitation, but we worked very closely, the elder law section worked very closely with the Attorney General's office here in Florida to pass a much more strict and highly strengthened law to hopefully dissuade exploiters from coming here to Florida and doing that bad work and exploiting our vulnerable adults. So there'll be more on that once the law rolls out. It takes effect July 1st, and we'll definitely get some more details out there for you all.
So let me bring everybody up to speed on some administrative changes that are looming here in Florida. You know, we deal a lot with advanced planning when we advise clients to do irrevocable trusts, and there's a 5-year look-back period, as you know. And we also have what are called crisis planning strategies, where if you haven't done a trust, there might still be ways in which we can help our clients to protect assets and qualify for government benefits. And it's, incredibly empowering for us to be able to do that and work with our clients in these ways. When we talk about doing an irrevocable trust, sometimes clients will ask the question, well, why should I do that if I can just rely on some of these crisis planning strategies at the last moment? And my answer to that question always is the same, which is, while we do have a number of different strategies that we can employ on your behalf, we can't always know whether those strategies will remain in place or intact. And over the years, there have been a number of attacks, if you will, either by the legislature or by Medicaid itself, in an effort to make it very difficult to use those strategies. And because of that ambiguity surrounding whether or not it'll be there when you need it, we always rely heavily on the certainty that doing an irrevocable trust provides. Well, recently, in the last month or so, here in Florida, there is a crisis planning strategy that we utilize quite often, I would say, because it's so beneficial, and that is the use of a pooled supplemental needs trust, which is a vehicle that you can use to place assets into and still qualify for Medicaid even the very next day, regardless of your age. So we were doing it for people 65 and over, we were doing it for people who were less than 65, and Florida happens to be one of the most liberal states when it comes to the ability to do that for a person of any age. Well, recently, Florida Medicaid came out with a Medicaid manual provision. This is the rule book, if you will, that caseworkers use, where they said that they were no longer going to allow transfers into pooled supplemental needs trust for persons 65 or over any longer. They were going to impose a penalty period, and that was going to disqualify the individual from qualifying for Medicaid. And the Elder Law Bar here in Florida is on top of this issue and vigorously opposing it and trying to work with Medicaid and the powers that be in order to come up with a solution that is workable for all, recognizing that seniors are going to be very negatively impacted by this rule change should it ever become official and formally adopted. But it goes back to the initial point that I'm making, which is if you really want to know for sure, the better approach, the better strategy is to do your planning well enough in advance, because if you have worked hard your whole life and you have a home, you have financial assets, and you're concerned about the cost of long-term care, maybe you don't have long-term care insurance, maybe you do have it but it's not adequate or comprehensive coverage, so you want to fill in the gaps. It's really helpful to have one of these irrevocable trusts in place, but as we know, we have to do it at least 5 years in advance. So we will keep you posted as to any developments with regard to this possible rule change and the ability to utilize pooled supplemental needs trusts going forward. Always it is our pleasure to work with our clients and to keep you informed of any developments. And as Ellen said at the outset, we wish all of the moms out there a very, very happy and safe Mother's Day, and we wish that you will all be well.